Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court dismissed the petition filed by Bilkis Bano seeking a review of its earlier order by which it had asked the Gujarat government to consider the petitions for remission of sentence of 11 convicts in the gang rape case. Bano was gang raped and 7 members of her family were killed during the 2002 Gujarat riots. According to the procedures, review pleas against apex court judgments are decided in chambers by circulation by the judges who are part of the judgment under review. The review plea came up for in-chamber consideration before a bench of Justices Ajay S. Rastogi and Vikram Nath, which decided to dismiss it. The apex court in a strict manner has disapproved of the police officials unnecessarily indulging in moral policing and thereby upheld the dismissal of a CISF personnel who was found to have harassed a couple at night. The single-judge bench of Justice Sanjeev Khanna observed that a holistic and pragmatic approach is required, especially when the Evidence Act is not applicable, and even when the Evidence Act applies, the enactment gives discretion on matters of evaluation, analysis and appraisal of evidence. The writ court, when disciplinary action is challenged, is primarily concerned with examination of the decision-making process, which requires satisfaction that the competent authorities have held her inquiry as per the prescribed procedure and have duly applied their mind to the evidence and material placed on record without extraneous matters being under undue consideration and relevant factors have been cogitated, the court added. The Supreme Court, in a division bench comprising of Justice K.M. Joseph and Justice Harishikesh Roy, observed that when the liability is capable of being estimated with reasonable certainty, the liability is not to be treated as a contingent one and should be considered as a liability which may be discharged at a future date. Another division bench comprising of Justice M.R. Shah and Justice C.T. Ravi Kumar observed that the Revenue Department was not entitled to commence the reassessment process while the rectification application was still pending. The court added that in the absence of any specific order of the withdrawal of the proceeding under Section 154 of the Income Tax Act, the proceedings initiated under Section 154 can be said to have been pending. The Supreme Court has observed that just compensation under Motor Vehicle Act should include all elements that would go to place the victim in as near a position as she or he was in before the occurrence of the accident. Next we have Delhi High Court. The Delhi High Court has dismissed challenge to Rule 9(2) of the Delhi Higher Judiciary Services Rules 1970 and affirmed that a candidate to be eligible to be appointed as a district judge in terms of Article 233(2) of the Constitution of India is required to be in practice as an advocate or a pleader for a continuous period of 7 years as on the date of the application. The division bench of Justice Vibhu Bhakru and Justice Pushendra Kumar Kaurav opined that the said rules cannot be said to be failing foul of Article 233 of the Constitution of India and on contrary is in conformity with the essay decision in Deepak Agarwal versus Keshav Kaushik and others. In its ruling, the top court found merit in submission that the expression "if he have been for less than 7 years as an advocate" as used in Article 233(2) of the Constitution of India must be read to mean 7 years immediately preceding his appointment and application and not 7 years at any point in the past. The division judge bench comprising of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad observed that it is certainly not the duty of the Constitution Court to regulate and monitor the movement of each citizen to see whether one indulges in public urination, spitting and littering. Terming the petition as sheer abuse of process of law, the court ruled that the concern raised by the petitioner would be better addressed by civic bodies and not by the court. The High Court of Delhi sought the response of the National Highway Authorities of India and the Centre to a petition challenging the rules making it compulsory for vehicle without FASTag to pay double the toll tax. A bench comprising of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad issued notice to the NHAI and the Ministry of Road Transport and Highways on the petition, which contended that the rule was discriminatory, arbitrary and against public interest as it empowers the NHAI to collect toll at double the rate if paid in cash. The single-judge bench of the Delhi High Court has opined that posting on Facebook cannot be treated as determinative of the location of a person as at a particular point of time, at least by a court. Another single-judge bench, while quashing an FIR against a first-year law student for appearing as a proxy counsel, held that a law student should not appear as a proxy counsel or counsel in court before being enrolled by a bar counsel and admitted to the bar. The Delhi High Court has made it clear that the Delhi government cannot rescind from its announcement to award an ex gratia payment to the deceased's kin, and the same can no longer be denied. The court ruled that the payments cannot be denied as there exists clear communication and messaging in the public domain via social media which leaves no manner of doubt that the compensation was promised. Now let's have an overview of other high courts. The High Court of Punjab and Haryana has permitted a kidney swap even though the people involved in the swap is not a near relative of the other, a mandatory condition under the current statute. The High Court allowed the patient's mother-in-law, who is not included in the list of near relatives, to donate her kidney as part of the transplantation swap. As per the Transplantation of Human Organs and Tissues Act 1994, only a spouse, son, daughter, father, mother, brother, sister, grandfather, grandmother, grandson or granddaughter are included in the definition of near relatives. Anyone outside this definition is not allowed to take part in a donation or a kidney swap. The Madras High Court Single Judge Bench of Justice R. Subramanian has ruled that the property transferred by the elderly cannot be taken back under the Maintenance and Welfare of Parents and Senior Citizens Act if the transfer document do not contain the clause imposing the condition that the recipient should look after the giver. The Kerala High Court modified the maintenance order passed by the Family Court and opined that the party must be allowed maintenance from the date of petition onwards as sanctioned by the law. There can be a deviation from only if specific reasons are recorded in writing, the High Court observed, and further noted that there is no reason for the Family Court to deny the maintenance to the petitioner from the date of the petition to which they are legally entitled. The Bombay High Court has noted that the scientific and technological advancements and observed that the DNA testing can exonerate the wrongly convicted and identify the guilty ones. It was pointed out that DNA testing has the potential to provide guidance in the investigation and improve both the criminal justice system and police investigation practices. The court further remarked that there was nothing on record to show that the accused was falsely implicated. The entire case of the prosecution rested on medical evidence, which was enough to prove that the victim was subjected to penetrative sexual assault. The Madhya Pradesh High Court has opined that the empty cartridges do not contain explosive, fulmination or fissionable material or any type of noxious liquid gas or other such things, and therefore empty cartridges cannot be said to be classified under the definition of ammunition under Arms Act 1959. The Madras High Court observed that the courts only have to see whether the Enforcement Directorate is acting within the ambit and scope of Prevention of Money Laundering Act 2002 and not misusing the powers. If court is satisfied that the investigation taken up is within powers and there is no misuse, then the court cannot act as a stumbling block in the further progress of the investigation. The Gujarat High Court has issued a notice to the company involved in the maintenance and operation of the Morbi Suspension Bridge, which collapsed in October, killing 135 people, on a petition seeking the company to be made a respondent in the suo motu proceedings initiated by the court. Moving on to miscellaneous news. The bench reserved its verdict on December 7th after hearing elaborate arguments from the government and the petitioners, who have contended that the demonetization decision was arbitrary, unconstitutional and contrary to the powers and procedure prescribed under the Reserve Bank of India Act. The Karnataka government has filed an affidavit in the Supreme Court and supported the prosecution of a husband under the marital rape charges. In its affidavit, it stated that the Karnataka High Court was correct in ordering the trial of a man for allegedly raping his wife. It was further submitted that whether the charges finally stands is a matter of trial and that the accused in the case cannot be exonerated at this stage despite the immunity against marital rape provided to the husbands under Indian Penal Code. Personal laws such as intestacy and succession, will, joint family and partition, marriage and divorce relate to entry 5 of list 3rd concurrent list of the 7th schedule of the Constitution. On questioning about whether the government is aware of the fact that some states are proceeding with the formulation of the Uniform Civil Code in respective states, he replied that the government is aware about the states who are forming committee for implementation of UCC. Article 44 of the Constitution provides that the states shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. In answer to another question, he informed Rajya Sabha that there does not appear to be any need for carrying out any amendments in anti-defection law as of now, because the provision of the 10th schedule have stood the test of time and several judicial scrutinies. The Repealing and Amending Bill 2022 has been introduced in the Lok Sabha in the ongoing winter session 2022. It seeks to repeal 65 laws that are obsolete or that have been made redundant by other laws. It also corrects a minor drafting error in the Factoring Regulation Act 2011. The fifth volume of the Reserve Bank of India's history has been released. This volume encompasses the 11-year period from 1997 to 2008. With this volume, the history of Reserve Bank of India is now updated to 2008. The Reserve Bank has initiated the process of preparation of this volume in 2015 under the guidance of the Advisory Committee. The Supreme Court is organizing a hackathon to encourage innovative ideas and explore practical propositions for bringing in efficiency in the existing process from filing to listing. It has invited suggestions and innovative ideas from the stakeholders for improvement in the system. A notification uploaded on the Top Court's website said that the event will be organized under the supervision and guidance of Top Court judges Justice Sanjay Kishan Kaul. In the end, we have international news. The US Federal Trade Commission has reached agreement with Epic Games that will see the video game giant pay a total of $520 million in penalties and refunds following allegation that the company violated the Children's Online Privacy Protection Act and used dark patterns, a UI design trick meant to fool users and dupe players into purchases. The younger brother of steel magnate Lakshmi Mittal was accused of being unreasonable and obstructive by a UK judge. Insolvency and Companies Court Judge Briggs denied permission to allow Pramod Mittal to appeal the revocation of his individual voluntary arrangement (IVA). French serial killer known as the Serpent, convicted of several tourist murders in Asia in 1970s, has been released from a Nepalese prison. Charles Sobraj, 78, was freed after court ruled in favor of his age and good behavior. He spent 19 years in jail in Nepal for killing 2 Americans in 1975. Sobraj, whose story was covered in the TV drama The Serpent, has preyed on mostly young Western backpackers on the hippie trail in India and Thailand. It seems that people will now need to be careful about sharing passwords of video streaming platforms like Netflix or Amazon Prime because it could drag them into a court case. Seemingly, those who are not living in the United Kingdom don't need to worry because this won't happen in other countries. The Intellectual Property Office of the United Kingdom has said that the password sharing practice is a crime as it violates the copyright law. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.